Welcome again to Bankruptcy Couch Counsel, a Hirschler-Fleischer video series on the legal and business issues and trends keeping business owners and business creditors up at night. This is Steve Leach, and with me is David Swan. We are bankruptcy lawyers in Hirschler's Northern Virginia office. This is the fourth of a four-part series on the options available to troubled businesses under the Federal Bankruptcy Code. In this episode, we're going to discuss an exciting new addition to the Bankruptcy Code. That addition is the Small Business Reorganization Act, or SBRA, which has been made a part of Chapter 11. The SBRA is designed to simplify and accelerate the process by which small businesses may reorganize their financial affairs under Chapter 11. For decades, bankruptcy lawyers have known and complained that Chapter 11 is too expensive and too complicated. The SBRA is designed to address some of these complaints. David, do you want to help us dive into the SBRA?
Thanks, Steve. So the SBRA went into effect in February 2020 and was available to companies with aggregate debt up to $2.7 million. Now, under the CARES Act, Congress raised the debt limit to $7.5 million so that many more small and medium-sized businesses would be eligible to use the SBRA. But unless Congress acts to extend that date, the debt limit drops back down to $2.7 million in March of 2021. Now, the primary goal of the SBRA is to make it simpler, cheaper, and faster for a small business to solve its financial struggles through a plan of reorganization. The SBRA does this by eliminating a number of requirements for a business to get a plan approved. Among the most important requirements that the SBRA eliminates is the requirement that at least some creditors vote to accept the debtor's plan. Now, under the SBRA, creditors still vote, but even if few or even no creditors vote to accept the plan, the company can still get the plan approved by the court. The key to approval is for the plan to provide that the company will distribute at least the next 3 years of the company's net projected income to unsecured creditors. Another issue for small businesses trying to reorganize that is that Chapter 11 would not allow owners to retain their ownership unless unsecured creditors voted to accept the company's plan, or if the plan provided that unsecured creditors would be paid in full with interest. The SBRA eliminates this troubling requirement. Now, owners of a company can retain their full ownership interests even if unsecured creditors reject a plan and will be paid only part and perhaps very little of what they're owed. This is a major step forward for small business debtors. Steve, do you want to discuss some other SBRA changes to Chapter 11?
Sure. Well, as David mentioned, a major goal of the SBRA is to reduce costs of the Chapter 11 process. Nevertheless, under the SBRA, a trustee is appointed in every case, and the business must pay the trustee for his or her work. But unlike a Chapter 7 trustee, a trustee in an SBRA case does not run the company. Management stays in control. Instead, the trustee serves as an advisor and attempts to bring the company and its creditors together on a consensual plan. So small businesses may have to pay for a trustee, but with luck, they'll get their money's worth. Another important point is that many parts of traditional Chapter 11 remain in force under the SBRA. For instance, even under the SBRA, a company that has a lease in default must cure the default as part of its plan or surrender the property, which means that a company that lacks the resources to cure a lease default may have to abandon the property, and that could be fatal for a small business. So while the SBRA is a big win for small business, it's far from a miracle cure. Well, David, that's probably enough breaking bankruptcy news for today. Would you like to wrap things up?
Thanks, Steve. If you have a question about the SBRA or any other bankruptcy question, let us know. And thanks for listening to Couch Counsel.